Hello everyone and welcome to our channel. So today I have another interesting topic for you. Remember last week I talked about domestic violence and I made mention of divorce. I said that one of the ways to put an end to domestic violence is filing a divorce action in court. So today I will be explaining to you what divorce entails, how to go about divorce, and what are the grounds for divorce. If you are new on our channel, kindly click on the subscribe button below. Under Nigerian law, marriage can actually end in two ways, either by death of the parties to the marriage or by dissolution by competent court. Now, under the Matrimonial Causes Act, there is only one single ground of which marriage can actually be dissolved, and that ground is such marriage has broken down irretrievably. So before I proceed, I'd like to give the definition of divorce. What is divorce? Divorce is the legal dissolution of a marriage by a competent court or by a competent body. So now, before you proceed to file a divorce action, you need to understand some certain things. Number one, you need to understand the type of marriage you are into. You know, we have different types of marriage in Nigeria. We have the statutory marriage, we have the customary marriage, and all. So you need to understand the type of marriage you are into. And you need to understand why you want to file the divorce. You can't just walk up to your lawyer and then tell the lawyer that if you want to file a divorce, or maybe you just wake up one day and just feel like, I want to divorce my spouse. So you have to have a reason for your divorce. Another thing is, you need to also think about what you want out of the divorce. What do I mean by that? You need to think about like the certain benefits you want from the divorce, such as the maintenance of the children, or maybe who takes custody of the children. So you need to also take note of that. You need to understand that. According to section 15 subsection 2 of the Matrimonial Causes Act, so grounds for dissolution of marriage can be proved in any of the following ways. Number one is the respondent refused to consummate the marriage. What do I mean by that? That is, the respondent refused to have sexual intercourse with the petitioner during the course of the marriage. But you need to take note of something. For you to prove consummation, you have to show that there was no sexual intercourse during the marriage. But where sexual intercourse occurred only once in the marriage, then you cannot raise the ground for consummation. So another ground for dissolution of marriage is that the respondent must have committed adultery with the co-respondent. What do I mean by co-respondent? Co-respondent is the person that was actually joined to the suit. So the respondent must have committed adultery with the co-respondent, and then the petitioner finds it intolerable. So, and another ground you can actually raise is that since the marriage, like during the marriage, the respondent has been behaving in such a manner that has become intolerable for the petitioner. What do I mean by that? In the case whereby the respondent is someone that drinks, or someone that takes hard drugs, or someone that just, someone that beats the husband or the wife. So that's kind of, you can actually raise that ground that such a person has been in that like throughout the marriage, you were not enjoying the marriage. It has become intolerable for you. So that is it. And another ground you can actually raise is the respondent has deserted the marriage for a period or for a continuous period of at least 1 year immediately after the commencement of the petition. What do I mean by that? after you filed the petition, the respondent has been out of the marriage, like maybe living apart, living somewhere. Maybe you are in, for instance, you are in Lagos, and then the respondent is living, like, because he saw the divorce petition, he left the house and then started living in somewhere like what, you guys are being apart after the filing of divorce. So that is another ground. Okay, another grounds for the solution of marriage is that the parties to the marriage have lived apart for a continuous period of 2 years immediately preceding the commencement of the petition. And then the respondents did not even object to the decree of dissolution being granted. So where the respondents object to it, like, after filing of the petition, and then the respondent is being served the petition, and maybe out of anger and everything, the respondent left the house and then started living somewhere for like 2 years. If the respondent did not object to it, it means that the respondent is actually satisfied with the divorce. So the decree of dissolution of marriage will be granted. But where the respondent objects to it, then you cannot rely on that fact again. So another thing you need to take note of again is that as regards the grounds for dissolution of marriage, is when the parties to the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition. That's another ground for dissolution of marriage. And another ground for dissolution of marriage is one of the parties have been absent. One of the parties have been absent long enough to be presumed dead. There are instances where some people, they just, they tell their partners that, okay, I want to travel outside the country. And then they go there and then stay there for years without even looking back. And even the partner does not even know whether this person is alive. There was no communication. There was nothing, like he does not even know whether the person is alive or dead. So such a person that is living, like, can actually file a divorce against the other one that is outside the country. So that is another ground you can raise if you are in that kind of situation and you feel like, okay, maybe you guys have been apart for like years. You can file a divorce petition against your partner and then move on with your life. So another grounds for dissolution of marriage is where the respondent fails to perform his or her conjugal rights. Where the respondent fails to perform his or her conjugal rights. So that is it. Now, I want to open your eye to something they call 2 years rule in matrimonial courses at. What does it mean, 2 years rule? No, we are talking about divorce. We also need to understand what 2 years rule means. So 2 years rule means that it implies that you cannot file a divorce you cannot file a divorce petition for any marriage that is 2 years, or below 2 years. I repeat, you cannot file a divorce petition for any marriage that is 2 years or below 2 years. So if you are in a marriage that there are actually exceptions to it. There are exceptions to it actually. The exception is that if you want to file a divorce for a marriage that is below 2 years or that is exactly 2 years, you need to seek the leave of the court. And what does it mean? Like, what does leave of the court means? It means you need to seek the permission of the court to file that divorce. And I know some of you will be so, like, you want to ask that, where can I file a divorce? Can I file a divorce by myself, or can I just walk up to the court and say, registrar, I want to file a divorce? So the truth is, or the truth is, you cannot file a divorce action yourself. If you want to file a divorce action, you need to seek the services of a lawyer. Like, you need to consult a lawyer to actually file that divorce action. So, and then the lawyer will file the action in the appropriate high court within your location. That is where you reside, or where the marriage took place. So that's all for divorce for now. I hope you've learned one thing or the other from the information I've given to you. So don't forget to subscribe, share our videos, and also watch out for more videos on divorce. Thank you for listening. Till we see next time, I remain Damilola Adesoya Esquire. Have a lovely day.